You know when you're reading a really dense legal document, maybe a contract or a statute, and you find yourself just completely skipping over that tiny little paragraph at the bottom labeled explanation? I mean, it seems harmless, right? It's just a minor footnote. But what if I told you that this seemingly innocent little blurb actually has the power to completely rewrite the entire law? What if it could retrospectively tax your business or entirely shift the burden of proof in a massive high-stakes lawsuit?
Well, welcome to this explainer. Today, we're going to demystify one of the most fascinating, misunderstood, and frankly, powerful tools in the entire legal drafting toolkit, the statutory explanation. We're going to look at the myths surrounding them, the modern reality of how courts actually enforce them, and the incredibly strict rules draftsmen have to follow when creating them. Trust me, by the end of this, you are never going to look at fine print the same way again.
Okay, let's dive right into our roadmap for today. 1. The anatomy of explanations. 2. The expansion myth. 3. The 5 core objectives. 4. The burden of proof. And finally, 5. Drafting rules and triggers.
Section 1. The anatomy of explanations.
At its core, an explanation is a statutory device that gets appended to a specific section. Its primary job is pretty straightforward, to clarify or explain the meaning of words contained within that section. But here's the absolutely crucial part. What happens next? Once it's enacted, it doesn't just sit on the sidelines. As established in landmark cases like Bengal immunity, it becomes part and parcel of the enactment itself. It's literally woven into the very DNA of the law.
Now, traditionally, the courts held a really strict view on this. In the Krishna Iyengar case, they laid out the golden rule of interpretation. Basically, the meaning of an explanation has to depend solely on its own terms. You can't just invent a wild theory about its purpose. For a long time, jurists believed its traditional job was simply to harmonize the text, clear up any ambiguity, and act out of abundant caution, just to allay apprehensions. Most importantly, it was meant to explain, absolutely not to expand, the main law. Keep that word in mind, expand, because things are about to get pretty wild.
Section 2. The expansion myth. So there is a stark, undeniable contrast between the old rules and modern reality. The traditionalist view screams from the rooftops, you must not widen the section. But the modern reality? Well, if a true reading of an explanation shows that it has indeed widened the scope of the law, the court has to give effect to that legislative intent. And they'll do it completely regardless of that harmless explanation label slapped onto it. Essentially, if it acts like an expansion, the courts are going to treat it as an expansion.
Let's see exactly how that plays out in the real world with the fascinating 1973 Hiral Ratan case. So the state of UP wanted to tax the first purchase of food grains. But the High Court struck down a tax on split or processed dal, basically saying, hey, it's essentially the same commodity as unsplit dal, so you can't tax it as a fresh, first-time purchase. So what did the state do to protect its revenue? They simply introduced Explanation 2 to the statute, legally deeming split dal to be a completely distinct commodity from unsplit dal. Boom! With one little explanation, they bypassed the court's logic and effectively made split dal subject to tax with retrospective effect. That harmless explanation proved to be a tremendously powerful weapon.
Section 3. The 5 core objectives. Now, if you are preparing for a law exam, you need to pin this next case to your memory board. We're looking at the 1985 landmark case of Sundaram Pillai versus Padabaraman. In this case, Justice Fazal Ali undertook a massive, sweeping analysis of the role of explanations across Indian precedents. And from that, he compiled what we now consider the definitive 5 core objectives of a statutory explanation.
Let's break these down, because the first 4 are super empowering for lawmakers. Number 1, explain the meaning and intendment of the act. Number 2, clarify obscurity or vagueness. 3, provide support to the dominant object. And 4, fill gaps and suppress mischief. But look closely at objective number 5. This is the ultimate safety net. An explanation must act as a boundary. It absolutely cannot strip away an accrued, vested statutory right that a person is already clothed with under the law. It cannot defeat the main provision. It always has to be harmoniously constructed with it.
Section 4. The burden of proof.
We're going to stay with the Sundaram Pillai case for a moment, which centered around a high-stakes eviction over willful default of rent. And here, we see an incredible strategic interplay between 2 tools, the explanation and the proviso. Quick exam prep signpost here. Treat the proviso clause as a legislative surgical tool. According to Sundaram Pillai, a proviso has a 4-fold purpose: accepting or qualifying the main text, providing a mode of relief, creating a condition precedent, or acting as an explanation itself. And remember the rule from the Bezawada municipality case. A proviso doesn't stand on its own. It depends entirely on the main section.
So apply the rule versus exception test here. The general rule is you get evicted for not paying rent. But the proviso carved out an exception, a mode of relief. It said if the tenant's default was not willful, they get time to pay instead of being instantly evicted. But right next to it was the explanation, which acted as a trapdoor. It explicitly deemed a default willful if the arrears weren't paid within 2 months of a written notice. This is a perfect example of looking for that provided that logic in drafting and seeing how it clashes with the explanation.
So what actually happened? Well, the landlord filed for eviction because the tenant had 6 months of unpaid rent. But here's the catch. The landlord never issued that 2-month written notice. He argued the notice was just illustrative. The tenant argued it was a mandatory condition precedent. The Supreme Court stepped in and ruled that if the 2-month notice is issued, a presumption of willful default automatically arises against the tenant. But because the landlord skipped the notice, the explanation didn't magically save him. Instead, a massive, heavy burden of proof fell directly upon the landlord to prove the default was willful. The explanation clarified the condition, and by ignoring it, the landlord completely lost his automatic advantage.
Section 5. Drafting Rules and Triggers.
Okay, let's talk about how these are actually drafted. The Emke-Salpaker case beautifully illustrates this first major rule, category restriction. In this case, the main section of the law dealt with both residential and non-residential accommodations. However, the appended explanation was explicitly limited only to residential ones. It essentially said that for residential properties, a newly constructed building owned by a tenant is deemed a secure alternative accommodation. The court strictly held that you cannot magically extend this explanation to restrict or modify the non-residential category. Its power is completely quarantined to the specific category it addresses.
And you know, sometimes identically worded explanations yield wildly different outcomes, requiring massive sweeping interventions. Take a look at this constitutional timeline regarding the Bengal immunity case. In 1953, the Supreme Court held that an explanation to Article 286 created a legal fiction that converted interstate sales into local sales for tax purposes. But just 2 years later, a massive 7-judge constitutional bench overturned that completely, severely restricting states' abilities to tax those deliveries. This created such an unbelievable legislative headache that by 1956, Parliament had to actually step in, pass the Sixth Amendment, and enact the Central Sales Tax Act just to resolve the chaos. Finally, let's talk about triggers and exceptions. A huge rule of thumb in drafting is that when an explanation sits at the very end of a section, it generally applies only to the immediately preceding subclause. It absolutely doesn't govern the whole page. Furthermore, explanations can be used to carve out massive, highly debated exceptions within the law itself. A prime example is the exception for marital rape that was carved out via an explanation under Section 375 of the IPC, which is now under the BNS.
So how do you actually know if an explanation applies to everything? You have to look for the universal trigger. Unless the draftsman explicitly writes a phrase like, "for the purpose of this section," which officially extends its application to all parts of the section, or states nothing contained in this section, its power remains strictly contained. The specific, exact words chosen are the key to unlocking the law's true boundary. Which brings us to the end of our explainer. We've seen how explanations can harmonize text, how they can literally be weaponized to retrospectively tax goods, how they shift the heavy burden of proof, and how their precise placement dictates their power. So I'm going to leave you with this final thought. Next time you read a contract or a statute, are you still going to skip over the fine print of the explanation? Or will you read it knowing it just might hold the power to change the meaning of the entire document? Thank you so much for joining me. Keep learning, and I'll catch you in the next explainer.